Biomedlex is an interdisciplinary, independent initiative of colleagues wishing to focus on issues related to regulation of in biomedicine, biotechnology. So this, I think we will have more events in the future, but in this year we started with 3 such events, the one related to abortion, the second was about transplantations, and this one is about surrogacy, which is of course a very hot topic in Greece and elsewhere as well. And allow me to first of all to welcome all the speakers today, but of course our guest speaker, Dr. Kirsty Horsey from the University of Kent in the UK. You know already from our announcement that Dr. Horsey is distinguished expert in surrogacy. You can see the details in our announcement. Will not go through these details in this introductory speech, but what I would like to point out is the expertise of Dr. Horsey in lawmaking and procedure in the UK in relation to our topic, to surrogacy. So I'm sure that you all are familiar with the problems that we address in relation to surrogate motherhood in Greece. It's been already 20 years after the adoption of this method by the Greek legislation. But of course, we know that the UK was the first country in Europe that has legalized surrogacy 30 years ago, or more than 30 years ago. Surrogacy remains, as you may know, quite controversial method in terms of ethics, and so far we don't have more countries, at least at the European Union and Western Europe in general, accepting that method as a legal option for couples wishing to have children. In the meantime, we have 10 years ago, less than 10 years, we have a very important judgment from the European Court on Human Rights in relation to surrogacy in France, and the attribution of citizenship in children that have been born through this method abroad. So all these developments create a landscape, I would say, quite interesting, at least in terms of ethical, societal, or of course legal aspects. So I would like, with these words, I would like to first of all to welcome once again and thank for accepting our invitation, Kirsty, Dr. Horsey, to present the experience from the UK and to make some first suggestions about our discussion, or providing some, if you want, some incentives for our discussion. So, Kirsty, thanks again a lot for accepting our invitation. It is an honor for us to having you in our seminar. And please go ahead. The floor is yours. Yeah, if you would like to share your screen, please do that.
All right. Thank you for inviting me, and thank you for having me. I should say thank you to Katia for twisting my arm to do this. She didn't have to twist very hard because I owe her favours. And like, we miss her in the UK.
I miss you too.
You're lucky enough to have her back over in Greece. Right, I'm going to try and share my screen and hope for the best. Is that working for you?
Yes.
Yeah. Oh, I don't want that though. I want the beginning. That. Okay, so Katia asked me to speak about just what's going on with surrogacy in the UK, and that thankfully is something at the moment, because for a long time there's been nothing much going on, and that's been my problem with the UK, and the fact that just, you know, it's been very static for so long. As was mentioned, we did legislate for surrogacy almost 40 years ago now, in 1985, and nothing much has changed since then, as I'm going to say in a moment. I have to apologise first if you can hear, I mean, it's raining so hard here. There's a window right by me. If you can hear sort of thunderous rain, sorry, I can't do anything to stop it. I wish I could. Okay, so what we're talking about in the UK at the moment is reforming the regulation that we have, that, as mentioned, already nearly 40 years old. And the reason it needs reforming is because it doesn't align with modern conceptions of what a family is or can be. It doesn't work with people's lived experience of surrogacy, and it doesn't represent the best interests of families, and in particular children created by surrogacy. And that's the sort of pretty widely shared viewpoint among people over here at the moment. So even the law that we have that governs legal parenthood following surrogacy dates from 1990, with some later amendments in the 2008 Human Fertilisation and Embryology Act. And I'm not sure how familiar you are with UK law, but what we have is a law that says the surrogate is always the mother. There is no question that anyone else could ever be the legal mother at birth. If she is married or in a civil partnership, then her spouse or partner will be the other legal parent. And there is a method of transferring legal parenthood to the intended parents called a parental order, which requires an application to a court and an assessment by the Family Court Advisory Service of home life and things like that. And the judge has to grant the parental order. And there are criteria that have to be met in order for such an order to be granted, most of which are, you know, relatively sensible, that, you know, the age limit of above 18 for the intended parents, and they have to be domiciled in the United Kingdom, or that's quite problematic. The home of the child has to be with the intended parents and things like that. But as anyone who has been following any UK cases knows, some of these criteria have been got around by some of the judges. So even sort of having the home with the intended parents, if the intended parents have separated, that hasn't stopped a judge making an order in favour of the child's best interest, because the home is with both intended parents. It's just that they don't live together anymore. There's also a 6-month time limit under which the intended parents are meant to apply for such an order, but that has been almost completely disregarded now, because it can't be in the best interest of children for there to be an absolute red line cut-off date like that. And in fact, last year, or maybe 2021, there was a parental order granted in favour of a now adult person in order to sort of legally connect him with his parents. So there has been a campaign to change the law. There have been people working sort of within surrogacy, you know, the people who support people going through surrogacy, lawyers, doctors, academics have been sort of making their voices heard. Judges have been very critical of the law. We have a sort of a bank of judges in the High Court who hear surrogacy cases. So we're not talking hundreds and hundreds of judges, we're talking sort of half a dozen over the last 15 or so years, when this criticism has been sort of growing. And because of that campaign, I guess, for reform, the Law Commission of England and Wales, which is a non-governmental independent body which reviews our laws, and the Scottish Law Commission, which is Scotland's equivalent, they held a joint public consultation looking at surrogacy law reform and sort of what should happen in 2019. And the reason they did that is because of the sort of push for change that was coming from all the places I mentioned, and they consult about what should be in their programmes of reform, and they had the most responses ever to their calls about what should be looked at in respect of surrogacy. So their report, so this is very timely, their report on the review of surrogacy law was published at the end of March this year. So we have an idea now about what they have recommended. And alongside the recommendations, they've published a draft surrogacy bill, which, if it is passed, would be new draft surrogacy legislation. But anyone who knows the workings of the UK Parliament will know that that's not necessarily an easy task. And, you know, what with everything else going on in our Parliament at the moment, could be some fun times ahead. So I'm going to look at sort of how we got to where we are now, and then look at the reforms that will hopefully come along on the back of this. So this is, hopefully you see the sort of arrows. I'm not going to go through all of this, but this is kind of the timeline you're looking at. So 1985 is when the first law on our Surrogacy Arrangements Act was passed. And as I said, we were the first country, I think, possibly in the world to legislate for surrogacy, and certainly in Europe. And so, but there's a 1985 plus, because nothing much really happened until 10 years ago. I mean, 2014 is maybe a bit extreme, because as you'll see, the first thing under that heading is that more surrogacy cases began to appear in our High Court from about 2009, and that was the advent basically of international surrogacy arrangements, and parents who had undertaken surrogacy in other countries coming back and needing to apply for parental orders, and that being that coming before the court for the first time around about 2009. But from 2014 onwards is really where the campaign, you know, asking for reform came from. There was a debate in the House of Commons back then. Judges became increasingly critical, and I've mentioned on there that it says SUK, which is Surrogacy UK, which is one of our non-profit surrogacy support organisations. Their working group on legal reform was created, and I was involved with that. And we published in 2015 a report, Surrogacy in the UK, Myth Busting and Reform, which was designed to push the reform agenda forwards by dispelling some of these myths that have grown up around surrogacy in the UK. You know, the kind of myths that surrogates only do it for the money, that intended parents will do it for convenience and not just because they need to. You know, all kinds of other myths as well about coercion and exploitation and, you know, all kinds of things. And from then, kind of support for reform picked up. As I mentioned, there were sort of lawyers, as in solicitors and barristers, who began to speak out. Judges began to speak out. There was another debate in Parliament, in the House of Lords this time, calling for law reform. This was very anglicised, but the DHSC minister under the 2016 flag, that's our Department of Health and Social Care, which is the ministry responsible for the law on surrogacy, which, I mean, don't get me started on, that's a whole different matter, that this is it's a health issue when it's actually a family law matter, but it's somewhere between the two, but, you know, who knows. Also 2016, you'll see Mary Warnock expresses support for reform, and that's significant because she was the architect of the 1985 law that we had. You know, she had published a big government inquiry in 1984, what's known as the Warnock Report, under which she came out, and the majority of the committee that she led came out anti-surrogacy, but they did recommend it be allowed under our legislation, but very cautiously. So what we have is a piece of legislation from 1985 that imposes criminal sanctions for people who help people make surrogacy arrangements, bans advertising, says that agreements are unenforceable, all those kind of things, because I think the intention was that it would make it so difficult that, and in her words, that it would wither on the vine. But that hadn't happened. And actually, Mary Warnock, having read the myth-busting report, actually said, well, hang on, I got it wrong. I didn't expect it to go like this. And actually, I see that it's a legitimate model of family building. And, actually, I've changed my mind. And I think it takes quite a big, strong character to change one's mind like that. And then you get the Law Commission starting, and there's this focus on lived experience going forward. And you have again, under 2017, you have this APPG, which is the all-party parliamentary group. Again, significant because that's not just one of our political parties, that is members of various different political parties coming together as a group within Parliament to sort of push the reform agenda forwards. And again, they are looking at sort of lived experience. So they had in 2018 a load of evidence sessions in Parliament, asking people with experience of surrogacy, both as parents or parents to be, or surrogates, or lawyers, or other people who've been involved in surrogacy arrangements to give evidence to them about their experiences. We also had at the time a remedial order passed in 2018, which changed some of our law. Up until that point, we had it was only possible for a couple to apply for a parental order to transfer parenthood to them, and this allowed a single person who was genetically related to the surrogate born child to apply for a parental order, having been ruled contrary to a single person's human rights for that to be forbidden. So that came about as well. So there's various tiny bits of change being made by the courts, and then this remedial order, which is a parliamentary order, which actually creates a regulation that changes the statute. So chipping away at things, and meanwhile the law commissions are looking at this in a very long project. It was nearly 5 years in the end, about how long it took. So, like I say, they've just published their final report, their recommendations. The 2019 consultation document that they published gave us some indication of the direction of travel that might be coming, although it hasn't exactly matched up with their final conclusions. But we have this surrogacy report. It's almost 1,000 pages worth of reading, if anyone's interested, plus a new surrogacy bill, which tells us where we could possibly end up. I won't go into this either. This is the work we did with the Surrogacy UK Working Group on Surrogacy Law Reform, the two reports we published, and these are the things we called for. Things about legal parenthood being automatically with the intended parents at birth, getting rid of the time limit, keeping data on surrogacy arrangements in something like a register collected centrally and published annually, etc., 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 and relaxing the bans on advertising. So we were pushing for a liberalisation, but with the evidence that came from families and people who had worked with people going through surrogacy as well. So this is what the UK Law Commissions have recommended. So as you'll see, this is the diagram taken out of their summary document, where they have summarised the main problems with the current law that they discovered, and then their recommendations for reform. So they found at the very top there that the intended parents are not the children's legal parents at birth as a problem. So they agreed with the people pushing for reform of that particular issue. And so what they have proposed is that if the conditions of a new pathway are met, the intended parents will be legal parents from birth. And that, I think, has some similarities with the way the Greek system works. I'm ready to be corrected, but more on that on the next slide. Also, I'm going clockwise. Surrogate born people lack adequate framework for accessing origin information, and so there is a proposed surrogacy register which will collect information which will be accessible to the child at a point in their life yet to be determined, but they will be able to access information about the fact they were surrogate born and who the surrogate was, and any donors potentially, although that might be on a different but linked register. We already have a donor register in the UK. Also a big issue, and this is one of the things that sort of contributes to lots of the surrogacy myths that have been perpetuated over time, is that the law on payments as we currently have it is unclear, very unclear, and difficult to apply in practice. So actually there is no real law on payments. It's not illegal to pay a surrogate in the UK technically, but what there is within the conditions for intended parents to be able to obtain a parental order giving them legal parenthood, it says that no more than reasonable expenses should have been paid to the surrogate. And obviously what's reasonable to one person is different for other people. And also when people are coming back from commercial surrogacy destinations, having paid the surrogate and many other people along the way, how that works then when you have the best interest of the child as the paramount consideration of the court has been caused a bit of tension within the cases over the last 10 or so years. The Law Commission was also concerned about the lack of safeguards for the participants in a surrogacy arrangement. So much of what we found in the myth busting and subsequent report, and sort of other research conducted by all kinds of people since, is that one of the biggest drivers for people to go overseas rather than to do surrogacy in the UK is the uncertainty about everything. Nobody feels safe. So the surrogate worries that the intended parents won't take the child at the end of the day, won't reimburse her expenses. The intended parents worry that because the surrogate's the legal mother, that she has all the rights, and she actually does, over everything, and she has sort of an ultimate veto. And therefore the children are not necessarily completely protected either. So this is linked to the top thing about who's legal parents at birth, but this new pathway to parenthood will have built-in pre-conception safeguards which protect the interests of all participants in such a way as sort of bureaucracy can. I mean, obviously there are ways around it, but the law is the law, and the people who choose to operate within it, then these safeguards will be in place. The other problem, and already kind of alluded to this, is that international surrogacy arrangements have their own issues, as well as the fact that they're commercial and the English model is not, but there's also been problems with facing a long time to bring children back into the UK, either because of our Home Office requirements, or obviously there have been issues with COVID and war and all kinds of stuff in the last few years. They're only proposing limited reforms to that. In the original consultation document, there was some consideration that there might be a kind of a recommended list of overseas destinations. So California and Canada were the ones that were commonly put forward onto that if surrogacy had been done in one of those destinations where we kind of know that it is well regulated, well performed, then they might be able to be on a Home Office approved list to be able to bring the children back quicker and get a passport quicker and avoid sort of immigration and other delays. But they've actually decided against that because it doesn't send the correct message. If they're saying that the model they're proposing is the best proposed model, then other models shouldn't, and particularly commercial models, shouldn't be validated by what our law says. I don't think they think that will stop everybody going overseas, but it might. But reforming the law domestically might encourage more people to stay at home, I think is the general hope. So this new pathway to parenthood, for me, this is the biggest thing that has been recommended. This has always been the thing I wanted to see happen was that the intended parents can become the legal parents at birth, with all that entails. So that's the right to do things like decide on medical treatment for the newborn should it be required, ability to get a passport, and even things like inheritance issues. If you're not the legal parent, you don't have succession and inheritance rights with those children. So this is this is the infographic taken from the Law Commission's summary report, the shortest version of their reports. And so you can see all these things pre-conception, the grey top half, all these things will take place. And this is where I think there are similarities with Greece, and lots of things taking place before the arrangement is even entered into. And these are designed to be safeguards for everyone, and in particular the child. So there are, medical and criminal records checks. Everybody gets independent legal advice. Everybody gets implications counselling. And importantly, there's this surrogacy statement that's signed by all the parties. And I guess that's kind of like a written agreement, but why they're not calling it that, I don't know, but could be tactical. There's also, you'll see there the second from last point, pre-conception, an assessment of the welfare of the child to be born through surrogacy. At the moment, that is done post-birth in order to get a parental order, and that is disliked by people who have children through surrogacy for obvious reasons. It is what happens for adoption here, but that would seem valid because you are dealing with a child that's already been born and not a child that was created to be the child of the intended parents. There's a whole question about whether that should be in there anyway, because under our law about IVF, there is already a clinical assessment that has to be undertaken that's a welfare of the child assessment. So there is question about whether that's doubling up, or whether that's whether they mean the same thing, whether that's a clinical thing, but then not all surrogacy has to go through a clinic. So there are questions around that. So I don't think the Law Commissions have answered all the questions. They've raised a lot of other ones, but this is progress at least. Then you'll see the pathway carries on, post-conception, hopefully conception anyway, through pregnancy to birth, and at the point of birth, the intended parents, if all those things in the preconception pathway have been followed and attested to, then they are the child's legal parents at birth. Although the surrogate can then withdraw her consent until 6 weeks after the birth. So they are the legal parents, but she can withdraw her consent. The crucial difference with that is at the moment, if the surrogate says no, there is an ultimate veto. This will be, the intended parents are the child's legal parents, but if the surrogate opts within that 6-week period to withdraw her consent, she is able to apply for a parental order to have the legal parenthood transferred to her. So it's basically sort of flipping that on its head. And then post-birth, they are recommending that the intended parents make a statutory declaration about any payments or reimbursement of expenses that they've made to the surrogate. And what I haven't mentioned yet, regulated surrogacy organisation will provide the information to go on the surrogacy register, this national surrogacy register, whereby children at a certain age will be able to find information about their things. And this seems to be quite significant. So this is a big change, that what we have at the moment are non-profit surrogacy organisations who are certainly who have paid staff, but they also have a lot of volunteers, and they rely on a lot of goodwill of their members. And in order to be able to help people going forward, they will need to apply to become regulated surrogacy organisations. And the proposal is that our Human Fertilisation and Embryology Authority will have an extended wing, arm, or whatever, which will deal with the regulated surrogacy organisations and will regulate surrogacy. The RSOs, regulated surrogacy organisations, will be licensed by them, and there will be some kind of inspection and checking up process like there is with clinics at the moment. And so these will have, you know, a pretty significant role, but that, you know, does raise questions about how they are to adapt and things like that. You'll see down the right hand side there are various conditions, so all this pathway only applies as long as these eligibility age limits and things like that. The key one on there is that at least one of the intended parents must have a genetic relationship to the child. That is currently in the law for being able to obtain a parental order. There has been a lot of pushback against that, to say that actually sometimes medically, you know, for genuine reasons, it might be that neither intended parent can provide a gamete in order to create the child. And in the original consultation, there was an option, but they were looking potentially at what's known as here as double donation being allowed, but they decided against it in the end. So that's the new pathway, which, like, you know, yay, but who knows whether it will happen. The question is, so what next? Well, what next? The government has 6 months from the date of the publication of the report to do an initial or interim response. So that will be end of September, that must come out by, and they have up to a year to provide their full response. And what that response is, we have no idea. There's no indication, although the Department of Health is who sponsored the review in the first place. So the fact that they put their money in it, and there have been parliamentary questions to say, you know, are you backing it? And they've said, well, yes, we'll wait and see what they say. You know, it would seem a bit funny if they then decided, actually, we're not going to do anything about surrogacy. But parliamentary time has to be set aside. We have, you know, weird arcane rules about how things get before Parliament, and the bill has to get there in the first place, and that requires political will. When it does get there, there will be debate in Parliament, and that needs to be informed by, you know, the best evidence available, by lived experience, preferably, rather than just, you know, myths and assumptions that are common. MPs need to be engaged and interested in a debate. There's so much else going on that surrogacy might be quite far down the list. We do only have, if you go by the number of parental orders, somewhere between about 430 and 440 parental orders granted each year out of a total number of births of about 600,000. So surrogacy is small. So to get MPs engaged and interested will require their constituents to lobby them, and, you know, lots of personal stories, that kind of thing. The other thing is that the organisations that are currently, you know, non-profit, semi-professional organisations will need to become regulation ready if this is to go ahead, and our HFEA, our Human Fertilisation and Embryology Authority, will need to be ready to regulate them too. So there's a lot to be done sort of behind the scenes even to get it there. And issues with that is we're running out of time in this Parliament. We're due a general election any time, and it could come sooner than we expect, given the state of politics that we have over now. So there's a lot of work also with things like the all-party parliamentary group to try and get a commitment from both the Conservative Party and Labour and others that surrogacy, pushing this forward, will be on their manifestos. And at the same time, there's this strong voiced minority view, which is becoming increasingly prominent. There's a very small but loud minority over here that is very anti-surrogacy and particularly anti not having the surrogate as the legal mother at birth. And so that is something that we are going to have to engage with and campaign against. And that is it. That's the UK.
Yes. Thank you so much, Kirsty, for this very stimulating, I would say, talk. And I guess it's now Katja's turn to give us a comparative aspect and between the UK system and
Sure, but before we go into my presentation, maybe I would like to ask Kirsty, so do you think that it's going in the right direction. What would you like to see in the new law in the UK? And also, do you think that the term regulated surrogacy statement was chosen because they're afraid of enforceability concerns and what that brings? Whether the surrogate should be then, maybe to explain for people who are not lawyers in here, when a contract is enforceable, it means that people have to adhere to everything that it says. So that could mean that the surrogate, if they write it on a contract, that the surrogate would have to eat specific foods or change her everyday lifestyle just to suit what the intended parents would like for her.
Or even if she has the right to terminate the pregnancy.
Yes.
Well, that bit is built in, that the surrogate would, so just not enough space to put it in all the slides. Sort of underpinning all of this from the recommendations from our law commissions is that the best interests of the child remain paramount, and that the surrogate retains full body autonomy throughout the process. It's only at that point, if that pathway has been followed, that at the point of birth the intended parents would become the legal parents. So when a baby has to have been born, and then, so up until that point she can decide what happens, and they're very clear on that. But I do think, Katia, that you're right. Choosing language in the way they have is to be a regulated surrogacy agreement is it's a surrogacy arrangement, but it remains unenforceable in the sense of being able to make the surrogate do anything. But it's well, from your studies, it kind of goes back to, there was another government commission report back in the late 90s, the Brazy report, and talked about a memorandum of understanding. And it is kind of that agreement. What do the parties understand will happen in this arrangement? And should everything go fine, then there's going to be no questions. But I guess it's there as a fallback. If the parties end up in court, then they can at least see what they agreed. And it's not just agreed between them, where they could have, well, you said this, but no, you said that. There is a regulated surrogacy organisation that witnessed and guided and and helped put that agreement together. What we have at the moment is that there's so much good practice out there that these agreements are being made anyway. There are really, really detailed surrogacy agreements that are made between intended parents and surrogates and witnessed by the non-profit organisations. And so I think quite a lot of what the law commissions have recommended is just what is already happening on the ground, but just giving it a name that sounds very legal.
Okay,
Indeed.
so Katia, if you like to continue with
Yeah, sure. Thank you, Kirsty. So I'll try to
just
share.
before Katia, just allow me to say to our attendees, please feel free to upload your questions or comments or whatever, objections, whatever, on the platform, so to enable our speakers to encourage the discussion. So yeah, Katia, please. Sorry.
No problem. I will just try to share my screen. I hope it works. Okay. Can you see?
Yes, perfectly.
Okay, great. So today's presentation, my presentation focuses on the Greek surrogacy law and also the findings of my own empirical research, to which Kirsty was a huge huge helper, because she was my supervisor, one of my supervisors. It was my own empirical research shining light into how surrogacy works in Greece and the UK. So I will take some of the issues that Kirsty has already mentioned and tell you how they work in practice as briefly as I can. So today I will start with an overview of the Greek surrogacy law, then we will move on to an overview of my research, and then I will go into the findings on access to surrogacy, regulation of surrogacy arrangements, and the findings on the determination of parenthood, and then some conclusions. Okay, for those who do not really know how surrogacy law works in Greece, I will just try to make a summary and begin with the ethical values that influence and inform the Greek surrogacy law, because they give us, I think, a good starting point to understand why the law is the way that it is. We have pronatalism and the protection of traditional ideas about what the family is. The recognition, promotion, and protection of reproductive autonomy. Actually, Greece is one of the very few countries worldwide that recognizes a right to have a child either through traditional or artificial means. And this is an extension of it is understood as an extension of the freedom of expression, which is enshrined in Article 5, Paragraph 1 of the Greek Constitution. So assisted reproductive technologies, or ARTs, are recognized as a way to treat the inability to have children naturally or to prevent the transmission of a serious disease to the child. And surrogacy is regarded as a form of assisted reproductive technology. And then the third principle informing Greek surrogacy law is, of course, and you heard it from Kirsty as well, the protection of the welfare of the child, the best interests of the child, which in Greek law is considered very important, but not paramount as in the UK. To give you an overview of the Greek surrogacy regulation, the model features are altruistic gestational surrogacy. So that means that the egg cannot come from the surrogate. Whereas in the UK, Kirsty has already mentioned that it's a gestational or traditional surrogacy. We have a written arrangement, preconception, judicial authorization, intention-based parenthood, and enforceability of surrogacy agreements, but not in the way that we've just mentioned. It only influences parenthood, and I will come back to that in a few minutes. So it's a very novel approach, especially for the European area, and let's not just say EU, but also for worldwide levels as well. Arts have been popular in Greece since the early 90s, but they had been unregulated. Prior to 2002, parenthood following surrogacy was established through gestation and birth. So the intended parents had to adopt the child. And now the laws governing surrogacy in Greece, basically it's two laws, the first two that you see in the list here. It's the 2002 law that regulates parenthood following assisted reproductive technologies, including surrogacy. And those provisions are incorporated into the Greek Civil Code. For surrogacy, it's Article 1458 and 1464. And it's also the law of 2005 that regulates assisted reproductive technology practice in clinics, the monitoring and license of clinics. It provides for criminal sanctions. It includes a definition of reasonable expenses for surrogacy. And then we have two more recent laws, one from 2014 and 2022. These two just introduce amendments to the other two laws. So basically the 2014 law abolished the residence rule for surrogacy. So the question that remains unanswered is whether Greece is now a new destination for international surrogacy. And the 2022 law, very, very recent, it increased the age limits for ART. It included provisions regarding cryopreservation of gametes and embryos, the option for gamete donors to choose whether they would like to stay anonymous or whether they would like to be known. And also it gave the National Authority on Medically Assisted Reproduction the power to regulate the manner and procedure for finding a surrogate by the intended parents, which was completely unregulated up until now. And there are a few decisions that are very, very important in terms of regulation that have been issued by the National Authority for Medically Assisted Reproduction, NAMAR, and relate to surrogacy. The first one is the 2008 decision. It related to the payment of expenses and reimbursement in cases of egg donation and surrogacy. Sorry, egg and sperm donation. The definition of the meaning of the term reasonable expenses, and it set a maximum limit of compensation to surrogates up to 10,000 euros. Then there are two decisions in 2016 that established procedures and monitoring bodies of the authority regarding the licensing of assisted reproductive clinics. One in 2017 that is recognized as the Code of Practice for Assisted Reproductive Technologies. And there we can see some provisions regarding suitability criteria for the surrogates. The question is this Code of Practice legally binding? Is it like a law? Because in its preamble, it says that it is a means of self-regulation and it applies alongside the Code of Medical Ethics. So that's a question also to be answered. The 2022 decision of 1680/2022, it provided for rules on the advertisement of assisted reproductive technologies. And lastly, and most importantly for us, for our discussion today, it's the most recent decision on the regulation of surrogacy. There are provisions in there for payments and reimbursement to surrogates. There are limits, set limits, and clearly defines what reasonable expenses should include. And also it gives the option to find surrogates through clinics and also make the payments to surrogate through clinics. So remember, because it is gestational only surrogacy in Greece, you have to go through a clinic and you have to have IVF for the embryo to be implanted into the surrogate. So let's go to have an overview of the legal provisions of surrogacy. Who is it for? It's for women who are single, married, in legally recognized civil partnerships or in enduring family relationships, who are under 54 years old. Recently, that was changed. It was 50 years old up until 2022. And women who have a medical need for surrogacy. So basically women who are unable to carry a pregnancy or bring a pregnancy to term, which relates to physical infertility. But then what about unexplained infertility? What about psychological infertility or social infertility? These are not really regulated. Is it for single infertile men? This is uncertain because we have had 2 successful cases of single infertile men getting judicial authorization to have surrogacy, to have a child through surrogacy. However, only one of those cases was overturned and the other one still stands. So we're still unsure whether single infertile men can have surrogacy or not. The reasons for their success in their application was that we should allow it for reasons of gender equality and for the protection of reproductive autonomy. Is surrogacy available to same-sex couples? We don't know. It's completely unregulated. And in my opinion, there is a definite need for reform because we already have the Civil Partnerships Bill of 2015 that recognizes a right to same-sex couples to form civil partnerships, and the law of 2018 that gives same-sex couples a right to adopt and foster children. So is surrogacy then the next step? Do we need to provide an express right to have a child through surrogacy to same-sex couples? Other statutory requirements are health checks for both parties, both the intended parents or intended mother and the surrogate. They go through a physical and psychological evaluation. There is a need for consent, which is shown by a signed surrogacy agreement and signed consent forms at the clinic. The permanent residence rule, we had it up until 2014, which meant that both women, the surrogate and the intended mother, had to be living in Greece. But this was abolished in 2014. So now either the surrogate or the intended mother must reside in Greece, at least temporarily. And there is evidence that foreign intended parents seek surrogacy services in Greece. There is a requirement for a preconception judicial authorization. This happens on the intended mother's application. It goes into civil court. The judge ensures the surrogate's autonomy, or is supposed to ensure the surrogate's autonomy, that it is not infringed by the written agreement that the parties had already signed. They check whether the parties have provided a valid consent. They check the welfare of the child, but there is no mechanism in the law on how judges are supposed to check true altruism. According to my findings and case law, judges very rarely refuse access to surrogacy if surrogacy is justified by a medical need. So is the judicial review that happens at the preconception stage just a rubber stamp at this point, just as a check to a list of things that you have to do in order to have surrogacy? The preconception judicial decision creates a legal presumption of motherhood, and it leads to the intended mother's automatic recognition as the legal mother after the child is born. And the enforceability of the agreement is thought to be an extension of reproductive autonomy, and it's thought to provide respect for the parties' intentions. But this legal presumption of motherhood that I've already mentioned is rebuttable, which means that if the surrogate proves that she is genetically related to the child, remember, it's gestational only surrogacy allowed, so the ova cannot come from the surrogate, then she can ask the court to recognize her as the legal mother of that child. And there is a time limit, 6 months from that child's birth, to do so. Let's go to the next slide. There are some legal requirements regarding the surrogate that are set by this National Assisted Reproduction Authority decision of 2022. The surrogate must be over 25 and less than 54 years old. For women between 50 years old and 1 day and 54 years old, you have to seek an authorization by the authority. And the surrogate must not have had more than 2 C-sections. Surrogacy agreements are not enforceable in the way that we discussed with Kirsty a few minutes ago. Enforceability only influences parenthood, so not everyday activities, which means that the surrogate still retains autonomy before and during the pregnancy. She has a right to withdraw from the surrogacy arrangement. She has a right to a lawful abortion. She has a right to consent or not to medical interventions. And how do IPs find surrogates and vice versa? The most recent decision by the authority said that the IPs can find surrogates through licensed assisted reproductive technology centers, so clinics, and make such payments to the surrogate through the center. Payments now, it's altruistic only surrogacy, except for the coverage of reasonable expenses. And what constitutes reasonable expenses? NAMAR answers the following: expenses for fertilization, we have IVF, the costs of IVF, pregnancy, birth, postnatal care, but that's based on receipts already issued, and the IPs have to cover such costs provided that they are not already covered by the surrogate's insurance provider. There is also a reimbursement due to loss of earnings, due to fertilization, pregnancy, birth, and postnatal care, and the limit is set at 10,000 euros. A reimbursement due to physical strain, up to 10,000 euros for if you have one embryo that you're gestating, and 15,000 euros for a multiple gestation. But there is no mechanism in the law on how to monitor any excess payments or any under the table payments. But right now we have a much more reasonable, I would say, limit set by the law, which is almost 25,000 euros, compared to the previous limit, which was set at 10,000 euros back in 2008. Advertisement and brokerage for surrogacy is illegal. The sanction is up to 2 years imprisonment and 1,500 euro fine. There is an exception for advertisement that was passed by the 2022 NAMAR decision. So advertisement for surrogacy is legal for medical professionals and other persons providing art services, art centers and cryopreservation banks, provided that the provisions of Article 24 of the Code of Ethics for Art have been adhered to. And now we go into my research. I will talk about the methodology, why I chose Greece and the UK, and then we will go into my findings. So this was a research that was part of my PhD in law. It was submitted to Kent Law School in the UK in 2018. It's a comparative socio-legal, it has a comparative socio-legal qualitative approach informed by a feminist perspective and combined with ethical analysis. It compares Greek and UK law, and also there's empirical data based on qualitative, in-depth, individual, semi-structured interviews, which took place in 2015 and 2016. So quite a while ago, but they're still relevant, I would say. There is evidence from 28 interviews, 14 in each country. And the interviewees were IPs, surrogates, representatives of surrogacy organization that is only for the UK, which already has such organizations, medical and legal practitioners, academics from 3 different disciplines, law, psychology, and medicine, and policymakers, both in Greece and the UK. The sample may seem small, 28 only, but it really captured the range of experiences of formal surrogacy arrangements that happen in Greece and the UK. There was a high level of consensus within my sample, which gives me some certainty that at least most of the things that I got were more or less correct. It makes a significant contribution to the literature, particularly given the paucity of empirical work in Greece. And I should say that the vast majority of surrogates interviewed in both countries were repeat surrogates, so they had done it more than once. And they were able to provide experiences from different arrangements that they had already entered into. And also it suggests that they had positive experiences in order to want to do it more than once. So why Greece and the UK? These 2 countries really have a potential for interesting and fruitful comparative study. There are 2 countries that have recognized the need to regulate surrogacy, but they vary significantly regarding the content of the regulation. So Greece has heavy monitoring in the beginning, altruistic, gestational-only surrogacy, written surrogacy agreements, preconception judicial approval, pregnancy only through IVF at a clinic, intention-based model of parenthood, and automatic recognition of parenthood to the IPs after the child's birth. In the UK, surrogacy is partially regulated, as we heard from Kirsty. It's only altruistic, gestational and traditional surrogacy. There is no need for a clinic if you go through the traditional route. There is no monitoring before and throughout the surrogacy arrangement as the law currently stands, which might change in a few months. And the determination of parenthood following birth happens through a parental order. We heard from Kirsty, the surrogate is the legal mother of the child at birth, and the intended parents have to apply for a parental order. There is very limited English written material about the Greek legal position for surrogacy, though it's very, very novel. There is scant surrogacy literature also from Greek scholars, and almost no evidence about how people experience surrogacy in Greece. Good up-to-date empirical data is also limited in the UK. There is almost no empirical data in Greece. But Pandelis is doing an excellent job on this, and he will refer to some data later on. Greece surrogacy, appears to be gaining social acceptance in both countries. There is evidence of an increase in surrogacy arrangements. Greece has lifted the domicile requirement in 2014, as I already mentioned. So there is a need to see how surrogacy is working now and how it will work in the next few years to answer to the question about whether Greece is now a new surrogacy hub for people who want to have a child through surrogacy. And the UK is reforming the surrogacy law. And it's important for such reform to be based on and reflect the lived experiences of surrogacy. So the Greek model could be an inspiration, but there's also a possible need for a modernization of the Greek law, because it's been more than 20 years now since its first adoption. And all the other amendments that have been made were only for just specific issues relating to surrogacy and not a wholesome review of the surrogacy law. And the areas of focus of my research is access to surrogacy, regulation of surrogacy arrangements, and determination of surrogacy, of parenthood, following surrogacy. So we now go into some of my findings regarding access. The welfare of the child is the only formal restriction affecting access to surrogacy in the UK at the moment. Greece has various statutory restrictions such as age, medical need, relationship status, that I've already mentioned. According to my data, only medical need and the intended mother's age posed significant limitations. However, now that with the new legal reform and the new age limit from 50 to 54, then maybe this is not a significant limitation anymore. In the UK, access is available to all social groups, but as we will see later, there are restrictions regarding the recognition of parenthood. In Greece, same-sex couples' right to access surrogacy is unregulated, but I found that same-sex couples do have surrogacy formally, I mean, using the formal route provided for in the law, but in unusual forms, or informally with the help of clinicians and lawyers. The most important limitation in both countries was, in the end, just cost, and the public funding was found to be inadequate by my interviewees. Both regimes failed to effectively address fair and equitable access to surrogacy to all, and there was a lot of unhappiness towards that. Availability and quality of information about surrogacy has increased in recent years. In the UK, the main source of information was the internet, whereas in Greece, the information mainly came through medical practitioners who were recognized as formal gatekeepers of surrogacy. So you have to go through a clinic. Who are you going to ask about surrogacy? Your doctor. Greek judges do not seem to examine surrogacy cases in much detail. They seem to facilitate, according to the experiences of my interviewees, they seem to facilitate access to surrogacy if it's medically necessary. And in Greece, medical and legal practitioners are probably involved in surrogacy matching, but they will not admit it because surrogacy matching is illegal if it's paid. Now, the findings regarding regulation of surrogacy during the arrangement. Greece seems to have a more robust formal system of ensuring consent through monitoring by the judiciary and through the clinic. In the UK, consent is monitored by clinics only if the parties go through one. The UK interviewees were unhappy about how consent is operationalized in clinics. They said it was just a check, just a tick, and they didn't really receive any formal information about surrogacy specifically. About assisted reproductive technologies, yes, but not surrogacy specifically. UK surrogacy organizations play a significant informal role in consent provision. The clinics in both countries, from all my interviewees, I found that they made counseling mandatory, although it's legally not required. And the reason for that was that counseling was regarded as a tool to ensure the welfare of the child to be born. People that were interviewed were happy about the respect for autonomy in surrogacy in both countries, but they said that this was often despite the law, not because of it. So they were happy with how consent was provided because they had made their own research and they knew a lot of things about how surrogacy works and should work. IPs, the IP's risk of harm, I was told, was greater than the surrogates, which is a common misconception that we see in the literature. And the risk of harm to the IPs is often overlooked at in the literature. Written surrogacy agreements was considered a good thing in both countries. I found no direct experience of exploitation, but mind you, these were people who had already had probably positive experiences of surrogacy, and this is why they came forward and they wanted to talk about their experience. So I don't know exactly what's happening in all surrogacy arrangements in Greece and the UK. And there was an overwhelming support for the principle of altruism, but they all said that the reasonable expenses system does not work very well, either in Greece or in the UK. Some said that the vagueness of the law, especially in the UK, in what reasonable expenses entails, offers some empowerment to the parties. In Greece, I found that there were a lot of under-the-table payments, but in the end, there was no evidence of harm from any excess payments in either country. And lastly, I found that there was a lack of effective regulation in both countries, but surrogacy works well in most cases because the parties try very hard to make it work, not because of the law. Lastly, the findings on determination of parenthood. So both systems were found to have weaknesses. The Greek law does not make parenthood available to same-sex couples and single infertile men. The UK law does not make POs available to people needing double donation, as Kirsty already mentioned, and up until recently to single people either. The Greek parenthood rules promote autonomy, respecting the parties' intentions, and seem to work well in practice, according to my interviewees. My UK interviewees noted that the UK law fails to recognize autonomy and intention, and it often leads to many practical problems. And the UK law is definitely weaker at achieving certainty of parenthood at the moment of the child's birth. UK surrogate said that the law on surrogacy awards them the wrong identity by recognizing them as mothers. They didn't want to be called mothers, especially not on a legal document, that is the child's birth certificate. And despite the widespread unhappiness about the UK parenthood provisions, the surrogacy arrangements in the UK that I had the chance to talk about worked very well in practice. Again, this was despite the law, not because of it. Enforceability was not perceived as limiting the Greek surrogates' autonomy or being harmful to them. Instead, it was found to protect the surrogates' welfare and to support the development of strong relationships of trust and friendship between the parties. UK surrogates also did not feel it necessary or appropriate for a legally recognized right to change their minds. They told me that we don't have to have that right because we know from the beginning of the arrangement what we're entering into. We will not want to change our mind later on. Greek surrogates also rejected that option. And in both countries, I found a lot of stigma around surrogacy and secrecy. This was much, much greater in Greece than in the UK. And in conclusion, surrogacy seems to work well in Greece and the UK, but this is often despite the law, not because of it. There is definitely a need for more research, especially qualitative work in both countries and particularly Greece. Future legal reforms should reflect the real experiences of surrogacy and should be informed by the real experiences of surrogacy. There is a need to establish effective monitoring and oversight systems, according to my interviewees, but they mentioned that they don't want over-regulation either, because that would be very limiting to them. And we need to create more awareness to eliminate the stigma and secrecy around surrogacy and ensure that information available is accurate and of good quality. Thank you for your attention and sorry for taking more time.
Thank you so much, Katya. It was so wonderful indeed. And yes, I think it's now time to hear Pandeli's intervention. Pandelis has done already a fantastic job in with research findings regarding the judicial experience of surrogacy in Greece. So, Pandelis, please.
Yes.
Take the floor.
Hello. Thank you very much for having me tonight. Thank you very much for allowing me to be part of this debate. I'm very, very happy to join such discussions, and I believe that it's very, very important for us to meet and exchange experiences and research findings. My research has to do with data derived from the court decisions that granted permission. So the Greek lawmaker since 2002 enacted legal provisions that allowed gestational surrogate motherhood in Greece. But what happened in practice? How many were those women that the intended mothers that recourse to court in order to take the permission? How many gestational surrogates offered themselves? How many permissions were issued? And more than that, even more than that, not only a number, but also what were their characteristics, their nationalities, their ages, or other aspects of that are interesting. Before starting, it is important, as also Dr. Horsey pointed out, to speak about the social context of every research. So some demographic information is necessary in order to further understand the findings. So according to the latest statistical data available, there are almost 100,000 children born per year in Greece. The total fertility rate has a serious downward tendency from the 80s up to 2015, 2018, thus remaining under the limit of generation renewal, which is set on 2.1 children per woman. The mean age of mothers at birth was 32 years old in 2021, compared to 29.5 years old in 2003 and 26.0 years old in 1975. And as far as assisted reproduction is concerned, it is claimed that an average 15% of Greek couples in reproductive age experience fertility problems that make them potential clients of the 48 licensed assisted reproductive technology clinics that operate in the country. So if we consider that, we can understand that after all, even the total, there are almost 500 cases that we have in mind, and we are trying to examine and further analyze. But even now, they are. It is not a trendy, let's say, a method of artificial assisted reproduction. It remains the last resort treatment, the last resort option for the intended parents. So this fact answers one of the concerns that someone might have regarding regarding the facilitation of access to a method that could end up being some sort of trend. No, this is not the case. So we see also that during the last years, there has been an increase in the judgments that were issued by the Athens court. And we see that the last 3 years, we have a decline. This can be explained because of the COVID-19 restrictions, but also because we have observed some stricter decisions and some stricter judgments from the judges that tried those applications during the last years. So that might be also the reason that we see the decline, because it was not a decline in judgments that were issued, but it was a decline regarding judgments that approved and gave the permission. However, the logic of this research is a modest one. It does not offer but a pebble to the mosaic of the relevant debate, because judging from the permissions, you cannot so easily end up with overall ideas regarding the whole process of gestational surrogacy in Greece. And also, even though Athens is the capital of Greece, there might be more and more interesting gestational surrogate cases in other places throughout the country, which we don't monitor and we don't have in our minds. So we have always to visit those findings under that perspective. However, I'm more than happy to announce to you that we have managed to make all data available in one website that has been launched recently, where you can find yourself the whole methodology and the whole findings of this research, and by use of filters, be able to extract your own results. If you care to visit this website address, ak1458.com, this stands for the Greek Civil Code article that refers to gestational surrogacy. There you might be able to see that it is very simple and modest, as I told you. The first page is that, and then you point to research data sheet, and then you can see the whole Excel sheet. And if you enlarge it, then you have the whole research in front of you. And by the use of filters, you can choose the results that you find of your research interest. This is done under a Creative Commons license. It is free for the scientific community, and feel free to explore it, feel free to browse it. And if you're, it would be fantastic if you could give us some feedback regarding how easy or less easy it was for you to end up with results. So we do monitor, we anonymize the cases. It's impossible, practically impossible, to track down the cases and the persons involved. We say which court issued which decision, and then we refer to the nationality and residence issue of both the intended mother and the gestational surrogate. We do care about the relation between them. We see and we monitor if the gestational surrogate appeared in court and took part in the procedure. We also see things regarding the reproductive material, if the parents chose to use their own reproductive material or if they recourse to donors. And then we do monitor also the medical reason for which the intended mother was unable to carry child to term. And so by the use of filters, you can choose and end up with results that will fit your research. I have tried to depict in several charts those findings that caught my attention. First of all, regarding the reproductive material, as you might imagine, the intended parents practically chose to use their own reproductive material if and up to the extent that it was possible for them to do so. So the majority used their own reproductive material. There is also the choice between using ova of their own or ova of a donor as far as the intended mother is concerned. That is logical because when applying for a license, they don't know if the method will succeed with their own ova and they wish to have this option. Now, if we go to the intended mother's marital status and nationality, we see that this also refers to a period of time before the latest enactment of several specific age limits. And we see that most intended mothers were married. They did not have children of their own. So it was seldom an option to have a second child. And they were mostly Greek, while the strict rule of residence applied, that is until 2015. The nationality of foreign intended mothers, we can see that they came from Italy, France, Germany, but also Great Britain, Israel, Czech Republic, Bulgaria, Albania. This is still the case, despite the fact that these findings go back to 2018, the mid of 2018. That's partially because of another rule of this research that does not intend to intrude to the family programming of the persons involved. So we let some years pass before, in order to analyze, before we start analyzing cases, so that we are sure that the children are born, that the families are formed, and that our scientific curiosity does not interfere with their lives while on this process. As far as the medical reason for the intended mother's inability to carry a child to term, we see that it has to do mostly with reasons that are really persuasive, that there was definite medical reason for the mother's inability. Reasons like unsuccessful attempts or unexplained infertility are not so seldom, but are not the most common that one would see as a reasoning. So indeed, again, it is a last resort treatment. We do not have any indication that there were intended mothers that used this as an option and not as a need. Now we can move forward with the gestational surrogate's nationality and marital status. There we see a difference as between their status and the intended mother status, because we see that they were mostly not married. They were mothers of own children, even before the rule that regulated that they must, in a sense, be already mothers of own children. And what is more, they were more resident aliens than Greeks. As far as their nationalities, the nationalities of the foreign gestational surrogates, they came mostly from Poland, Bulgaria, Georgia, Albania, Romania, generally the Eastern Bloc countries. And we do have a population of immigrants, working immigrants, legal working immigrants in Greece coming from those countries. And as it seems, they also offered to become gestational surrogates for the intended mothers in Greece. Now we can see that in comparison and see the differences of the nationality and marital status between the intended mothers and the gestational surrogates. One of the most interesting findings And one of the most undoubted, let's say, findings of this survey was that whenever they actually said to the court what their relation was, what made the gestational surrogate offer, it was often either a typical announcement of friendship, we are simply friends, we know each other, or there were clear indications that the gestational surrogate was an economically dependent worker as to the intended mother. So that really is a finding that does not allow us to undoubtedly accept the altruistic motive, because if there was to be an altruistic motive, then we would have cases where the economically dependent worker would be the intended mother and her boss would be the gestational surrogate, but this was not the case. However, it is not something that, again, we can draw conclusions directly from, because foul play could exist even in relationships and cases where it seems that no foul play would exist, like sisters or relatives, because the balance of power between the intended mother and the gestational surrogate is not as obvious as one could imagine. However, this raises an issue of visibility regarding the gestational surrogate's body, her interests, and generally her status in this process. Only in 69 cases, we had actually the actual presence of the gestational surrogate in court. One could say, okay, the lawmaker did not make it obligatory, but apart from that, it did not happen also in practice. And I firmly believe that it has also a concrete symbolic meaning, because the whole law and the perception of the whole method focuses on the need of the intended mother. We listen to her need, we respect her need, we say light to her need, but it does not do the same thing with the gestational surrogate's personality and needs and body, and very easily, I might say, and very comfortably accepts her offer, her altruistic offer, simply upon her declaration that this is the case. And this is something that I believe should be reconsidered in a reform, in a legal reform, that in my personal opinion, it is due. Years have went by. It's high time we had a discussion regarding a legal reform, aiming, as I said, the visibility of the gestational surrogate, aiming at regulating the offer and request for a gestational surrogate procedure, and also taking always in, also, again, I'm personally clearly against the abolishment of the permanent residence rule that took place in 2015, because the initial form, the initial logic of the law was against reproductive tourism. However, even if it is to be the case that we are going to allow Greece to act as a legal forum for gestational surrogacy, this would preferably done within a debate, a greater debate regarding a law reform, and not simply by changing several foundations of the existing law. And we shall also have in mind, that's my last slide, that legal reforms take time to become, to be depicted in reality. We can see here the difference before and after the law's amendment regarding the residence. It did not happen until the third or fourth year after the law's amendment that we saw foreign residents coming and trying to get licenses, to get permits as intended mothers. So any reform will be depicted in findings like ours only after 2 or 3 years. And that's important to bear in mind. that's actually what I had to tell you. I hope that I didn't take too much time. I repeat that this is a modest research offering just a pebble to the mosaic of this debate. Thank you very, very much for taking the time and listening to me.
Thank you so much, Padeli, for this really interesting and very fruitful intervention and concise in terms of time also. Now, I think that you have opened room for criticism regarding the Greek law, and possibly Kostas has this point of view, adopts this point of view. So Kostas, please, if you want to take the floor.
Thank you, Takis. Thank you for having me. Before I start, I would like firstly to disagree about the modesty of Pantelis. His research is not just a pebble, it's the whole mosaic. And the people that are here have to know that this extensive research to the decisions of the court of, especially to the Court of First Instance of Athens, has not received any finance, and it's the result of the personal passion and work of Pantelis Ravdas. And since I have studied the case law of several other countries, I'm not aware of such an extensive research in the data of other courts. So even though there are more elements that we need to know in order to regulate in the best possible way surrogacy, the contribution of Pantelis Ravdas is really very significant, and it is also significant because Greece is the only civil law country that has legalized surrogacy. So I will start now my presentation. I will share my screen. Okay, now I'm ready. So the title of my presentation is Surrogate Motherhood in Greek Practice, Lack of Transparency and Prevalence of Manichaean Perspective. Of course, this presentation of surrogacy as Manichaean is not related only to Greek legal framework, but it's common also in other countries. There is a distinction between altruistic and commercial surrogacy. Over the years, in some prohibitive legal orders where there is an ongoing discussion, it has been thought that an altruistic model would be perceived as a satisfactory alternative to the commercial surrogacy. I will try in my presentation to examine if such distinction between commercial and altruistic surrogacy is really meaningful. I will try to show that there are some fallacies and some drawbacks in this distinction, that instead of helping us, it can be the cause of different problems, both in theory and practice. At the end, I agree with Pantelis that it is high time to reform the legal framework of Greece, but not only of Greece, but of other countries. And I have some proposals that I would like to present you and eventually to discuss. So there are some questions in relation to altruistic and commercial. What is the meaning of commercial surrogacy? What is the meaning of altruistic? What do we mean altruistic? Is there a maximum amount of compensation above which a surrogacy stops to be altruistic? Does the absence of compensation makes always a surrogacy altruistic? And does the existence of a compensation in surrogacy procedures excludes any element of altruism? So from the point of view of a prohibitive country, and we know that the majority of countries in Europe prohibit surrogacy, there is no point to distinguish between commercial and altruistic. There is this idea that surrogacy is inherently exploitative of surrogates, that it promotes commodification of human body, and those are some of the reasons for which surrogacy is completely banned in a big number of countries: Germany, France, Italy, Spain, and most of countries in Europe. However, it has to be noted that the big majority, if not all the countries, I have not seen a country, although they prohibit surrogacy, they guarantee in different ways either the recognition of children born through surrogacy abroad or the reconstruction of parentage with intended parents that had recourse to surrogacy abroad. I believe that most of the arguments against surrogacy do not seem to be convincing. And one of the main reasons for this is that although those countries prohibit, they do guarantee the recognition or establishment of parentage. Of course, we should not neglect that this situation, as regards recognition, could change. The last month, there is an ongoing debate in Italy and a bill that is before the Italian Parliament to adopt stricter sanctions against surrogacy. Surrogacy is already illegal in Italy since some years, and there are jail terms ranging from 3 months to 2 years and fines from 600,000 euros to 1 million euros. The idea of the government of Prime Minister Meloni is to make surrogacy a universal crime that would punish people that go abroad to have a child via surrogacy in countries that are legal. We don't know if this will become a law, but it seems that there is a majority to pass this reform. I want also to stress the fact that even though there has been this prohibition in Italy and these fines for all the previous years, there have been couples going abroad for surrogacy and that had systematically managed to have their parentage recognized, except in one case, the Paradiso and Campanelli, who went before the European Court of Human Rights. So let's see the questions that I have tried to ask. What is the meaning of commercial surrogacy? So commercial surrogacy, which is practiced in some countries, in several states of the United States, like California, in Canada, although in Canada it's a little bit more mixed, kind of mixed model. It is openly accepted to have a remuneration, let's say, of the surrogate. This is true also for Ukraine, which has been a major destination, especially before the war. What is the meaning of altruistic? And I will try to answer this question by taking into account what has already presented by Katya, especially. Does the altruistic model exclude any kind of compensation? The answer, as you have understood from the previous presentations, it's clearly no. The Greek law has created an independent authority which created maximum amounts of legal compensation. Initially, the maximum amount would be 10,000 euros. And since the last modification, since the last decision of the Greek authority on medical assisted reproduction, it can go up to 25,000 euros. Something which is extremely interesting is that the participants do not even have to prove that there have been those expenses. So those decisions say that the intended parents just have to submit a declaration under oath that there have been those expenses. And even if we take the situation before the last decision of the Greek authority, even 10,000 euros, it's not a sum that is unimportant. Because, of course, we know that although Greece is a member state of the European Union, there are people that are under the poverty limit. So 10,000 euros would be a significant sum of money for certain people, would be a significant motivation. Does existence of a compensation surrogacy procedure excludes any element of compensation, of altruism? This is a difference in understanding, perhaps also with what Panteli said. I don't believe that the fact that there is a compensation or even a remuneration means that the person who engages in a surrogacy procedure does not have any altruistic motivation. And if we think for a moment, all those professions that have a direct contribution to other people or the society, like doctors, firemen, and so on, we can in my opinion, we cannot say that those people are only motivated by their intention to have a profession and earn their living. I think that altruism might have been one of the motivations for choosing this profession. And I believe that even in cases where the financial compensation is the main reason for the gestational surrogate, altruism can also be a motivation for them, and the fact that they manage to help. Another problem that I have with this distinction between commercial and altruistic derives from the following question. Is there a maximum amount of compensation above which a surrogacy stops to be altruistic? I see that the answer provided by the Greek legal framework is not satisfying. And it's not satisfying because initially we thought that 10,000 euros would be the maximum limit. And suddenly, all of a sudden, without sufficient justification, without sufficient debate, we said that this sum could go up to 20 or 25,000 euros in case of twins. Does the absence of compensation makes always a surrogacy altruistic? And here I'm going back to one point that Pantelis raised, as about the power relations, even in cases where there is no exchange of money, for instance, within families. Couldn't we have problematic situations when a sister becomes a surrogate for her sister? Isn't there a possibility that there is a power play or a pressure from a member of the family towards a sister or to another member to become a surrogate? Are those situations completely without problems? The answer, as you can understand from the way I'm asking the question, is that also those situations, despite the absence of the compensation, could be problematic. So the absence of compensation does not guarantee that the exploitative nature of surrogacy procedure will be excluded. So I said, I clearly believe that this distinction between a commercial and altruistic is not representative of the reality. And I believe also that this distinction, which I characterize Manichean, is the source and the cause of several problems. Those problems have been obvious in the UK, for instance, where, as we already heard Katya and Dr. Horsey, it is clearly unsatisfied the way of how we determine what reasonable expenses are. And then we see from case law in the UK that there have been several couples that went to foreign countries to have access to surrogacy in legal orders that allow commercial surrogacy. And later on, the amounts that have been paid that were well above what is considered as reasonable in the UK have been authorized by the courts, by UK courts. And of course, a parental order has been granted. The parentage has been maintained. Let's say in Greece, I share the opinion of Pantelis that there is a lack of visibility in Greece. There is a lack of transparency. And this can be very, very problematic. I believe from my experience, from my research, from the opinions I have shared with several professionals, that in most of the cases, the financial compensation is a main motivation. Although there are surrogacies that take place within the context of a family. And it seems that judges are aware of that. One of the problems with this dichotomy between altruistic and commercial has been observed recently by some judgments of the Court of First Instance of Athens, which have started to systematically reject some applications for surrogacy. The reasoning of the court that started to reject was the following. The judges started to search in their database in the Court of First Instance of Athens. And every time they saw that the intended mother appeared twice or the surrogate appeared twice, they were developing the following reasoning. It is impossible that this intended mother is at the same time friend with this surrogate and friend with the following surrogate. So there is a hidden compensation. So the conditions of surrogacy are not met. I reject. And in some of those cases, the files were sent to the prosecutor's office to investigate criminal violations. It is problematic, the current model, because there are risks. If, for instance, the intended parents decide to abandon the surrogate at the moment of the birth and not pay the minimum compensation, let's say. We can understand the need of judges to react to this phenomenon of cross-border surrogacy that has taken place in Greece, especially since the abolition of the residence requirement, but sometimes their reaction is ill-conceived, and they do not go deep to understand what are the difficulties that the couples have, what are the reasons for which the intended parents have had access to surrogacy. For instance, in one of the cases where an intended mother applied for 2 consecutive times for surrogacy, was that the first surrogacy procedure had failed because the first surrogate, after having received the authorization, got pregnant with the sperm of her husband. So the whole procedure stopped. In another case involving a couple from France, the whole procedure started without problems. And because of the significant delay and because of the pandemic, the intended mother had a serious health issue, which led to her death. She had cancer, there was metastasis, and she died. So the surrogate decided to help another couple. So she appeared twice. The Court of First Instance of Athens, who saw this fact, said impossibility of a friendly relationship. So there is a hidden financial compensation. So the conditions of the Greek law are not met. So this lack of transparency entails also some other risks. The surrogates, we could have situations where the surrogates are not compensated. There could be situations where the surrogate could die, there could be side effects or adverse incidents following the surrogacy. And the fact that the compensation, the damages, and all these parameters are not clearly regulated in the Greek law is a major concern. So my point is that to try to think and to promote the idea that an altruistic model is the absolute truth and the absolute solution to surrogacy is not accurate. I think this does not mean that surrogate is not a difficult and complicated procedure. This does not mean that there are not risks that are inherent to surrogate. But I believe that the best possible way to deal with these difficulties, to deal with these risks, is by admitting that there are some financial parameters in surrogacy, because in that way we will be in a better position to protect all the people involved, and we limit in that way the margin of exploitative practices. I believe that this transparent regulation and the acceptance of these financial parameters will lead to a better protection of all the parties. Apart from that, I have some proposals that I would like to formulate that I believe that could be helpful. I believe, first of all, that prohibitive countries, taking into account these realities, should try to accept and legalize and regulate surrogacy, even in a limited way. But this would limit people from going to other countries where the practices that are followed can be more problematic. I think that the surrogate and her family must receive counseling prior to the procedure from the independent authority. I'm not saying from lawyers in Greece, because I don't believe that there are sufficient professionals that have the adequate know-how to counsel. So I believe that this role could be played in Greece, for instance, by the independent authority. Intended parents should be obliged to sign an insurance contract covering healthcare costs, or at least to have some other safeguards that will guarantee the payment of costs arising out of healthcare. And intended parents the surrogate and her husband or partner should be obliged to produce a criminal record certificate. This, of course, does not constitute any absolute guarantee, but it is better than nothing. I agree with Pantelis that surrogates should be habitual residents in the country where surrogacy takes place. I think this is important, but I don't agree with him that the intended parents should be habitually resident in Greece. And although I do agree that eventually the idea that the legislator had in his mind in 2002 was not that we would have such a cross-border access to surrogacy, I don't believe either that they had considered this eventuality seriously and they had excluded it in an intentional way. Given the lack of legal frameworks that regulate surrogacy, I believe that Greece should remain an open destination for intended parents, but we should prohibit gestational surrogates to move from other countries to Greece to act as surrogates. We should create mechanisms that guarantee the reimbursement of surrogate. We should provide through public information campaigns by independent authorities necessary information. This could eventually push more women to become and act as surrogates. I believe that it would be useful to have a public record and statistics for surrogacy for the women that have acted as surrogates, and eventually create a limit for women that eventually they could not act more than 3 times. And finally, I believe that both countries that allow and prohibit surrogacy should cooperate to sanction exploitative behaviors, such as abandoning the surrogate without covering healthcare costs or the minimum compensation. And I believe finally at the international level that we should try to disseminate information, as I believe that it has been highlighted by Katya, that there are some destinations that adopt best practices. For instance, California or Canada and some other legal orders. So I would like to conclude this presentation by quoting Jean Tirole, Nobel Award for Economics. Jean Tirole says that it's better to analyze the market's failures to determine the best public policies instead of simply becoming indignant against them. And finally, at some point in one of his articles, he says, our feelings of repulsion are not a reliable guide to ethics. We have to better understand the foundations of morality and the fears of commodification. This is all I wanted to say. I believe that the need for reforming the Greek legal framework is imminent, and not only for the protection of the people that are involved in surrogacy, but also for the protection of professionals, medical professionals, and people that are active in this field, because it suffices 1 or 2 bad cases to destroy the important reputation that good clinics of assisted reproduction have abroad. And if we take into account the reflexes of the Greek legislator, who very often reacts impulsively, a bad publicity, a bad event around surrogacy could lead the Greek legislator to completely prohibit surrogacy and stop and destroy a model that in general is satisfying, in my opinion, if I compare it with other models, instead of trying to adopt reforms that can improve the existing legislation. So this is all I wanted to share with you. And I thank Biomedlex and all the participants here for this event.
Thank you very much. That was wonderful, Costa. Very interesting. I think it was very relevant to also to the issues that have been raised by the other speakers. I would like, first of all, just to again to invite you to open your microphones and ask whatever you want or make comments or whatever, our speakers. And I have already request from a medical doctor,
Yes.
gynecologist. So yes, we can hear you. Can you give us your name, please?
My name is Pandinos Mavrogenis. I'm based in Nicosia, Cyprus. I'm a
Wonderful.
gynecologist. I've been a gynecologist and obstetrician for 30 years. And I'm currently doing a master's degree at the Open University in bioethics. And I would like to thank all of you for this very, very interesting and enlightening discussion. And given the opportunity, I would like to kind of highlight a few points, because being a medical professional for so many years, you can see that theory sometimes is something completely different than what is really happening. Now, the basic questions that everyone is trying to address is, do we really need it? Because, and that's a very difficult question, because it is not surrogacy, as well as just like IVF, they're not going to solve the population decline in the developing countries. But it is there. There are indications, there's some absolute indications, medical indications, where it is needed. And therefore it should be regulated some way, because if you don't regulate something, it becomes a gray zone, and that becomes very dangerous. So there are some things I would like to point out. We have gone down a path with IVF, which actually accepts the fact that you can actually commercialize medicine in certain fields. One example, you cannot, it's very clear that you cannot trade human organs or biological material, but you can sell your eggs and your sperm. And what do they get? It's compensation. Now, we have a lot of people wanting to do IVF, and we don't have enough eggs. So when I tell you that a woman gets something around 1,000 to 1,200 euros as compensation for giving her eggs, now what is that? Is it a transaction? Do we sell biological material, or do we just want to hide behind our fingers and call it altruistic donation or something like that? And I start with this because this is where we're going, and this is the trend. And I'm very grateful to the last two speakers for going on this thing, because there are also some things that create discrimination. For example, in Cyprus, we also have a legal framework. The surrogate mother is allowed financial compensation. A woman that wants to give her child for adoption, for mainly economic reasons as well, because it's all about money in the end. A big part of it is a financial issue. You don't have an executive in a company, okay, with 10 years experience or 15 that's going to become a surrogate and quit a job for 9, 10, 15 months to be a surrogate. But she will probably, this executive, this middle class, highly successful, well-paid woman, would probably pay someone so she doesn't have to go out of work for 9 to 10. And this is the dangers that we're going. So in Cyprus, a woman can actually be compensated financially. But if a woman wants to give a child for adoption, she even has to pay the expenses of her delivery. So there's a great imbalance between these two.
Okay, thank you. I think it's very clear. You like to add something?
Also, this thing, if we do allow, which I agree with Dr. Rokas. I mean, if we do allow this form of compensation, financial compensation, and try to regulate it, in the end, only rich people can do it. Poor people are not going to be the receivers. They're going to be the surrogates. So we have another thing that we create on a social level between the haves and don't haves, let alone the whole story of rich Americans, Canadians having surrogates in the Philippines and India and Africa, which are completely horrible stories. But I will just give you an example of what was going on in Cyprus, okay? Because we did have surrogacy. For understandable reasons, unfortunately, it was the doctors who were involved in IVF that marketed this method. I will use the word marketed. And the recipient country was Ukraine. Now, the legal framework in one country has to be in some correlation with the surrogate mother in another country. So what was happening in Cyprus? They were saying, okay, it was more of a, they were trying to persuade everyone that a woman from Ukraine was coming in Cyprus, underwent IVF, okay? Doesn't really matter where her eggs or donor eggs or sperm, it doesn't really matter. She would become pregnant and then she would go to the Ukraine back and deliver the baby there. Why all this? Why couldn't she stay in Cyprus? Because the law in Cyprus actually states that the mother is the woman who delivers the child. Where in Ukraine, it's not like that. So what is this opening? Well, they were selling babies.
I think it's the known problem of surrogacy tourism, and please, if you like to shorten a little bit your intervention, because we don't have enough time.
Right, it's illegal. It also opens a window for illegal adoptions.
Okay.
These things are quite dangerous, and these are happening. And I'll even tell you the prices. We're talking about 50 to 80,000 euros for surrogacy. I don't think this is just a case of surrogacy. And the police in Cyprus have investigated, and Mr. Rokas, Dr. Rokas, they found nothing. They can't find anything. So this is the reality. This is a new reality, and this is what's going to be happening. We should be very. Thank you.
Thank you very much. So please, Kirsty, would you like to comment on this intervention, Dr. Horsey?
Only to say, you know, what you just said, which is there's a known problem of surrogacy tourism, and that's what national laws have to seek to curtail in some way, like if it's possible. I mean, so in my view would be that if you made surrogacy more attractive at home, then fewer people will go overseas. But I don't think we'll ever stop everybody going overseas, because some people do it because it's, or at least the perception of it is quicker or more certain, or, you know, more guaranteed. And some people don't have the patience to wait, or you know, or they don't want to wait, or they don't know. So I'm kind of hoping that the changes that might happen in the UK, or even just the debate about the changes, might make surrogacy more visible, and this model of surrogacy that exists in the UK more visible, and therefore will make more people seek that route out first, rather than just going to Google and saying, you know, where can I get a surrogate? Because you do hear of some practices elsewhere that are not necessarily great. And I noticed Georgia this week is said as the latest country to say we're not going to let foreigners come here anymore for surrogacy, which is the latest in a chain. So, but inevitably that will probably mean that surrogacy will pop up somewhere else. But yeah, so all we can do as nations is to regulate our own citizens, and hope that our regulation is good enough that it encourages people to do it in the model that we have, quote unquote, democratically chosen.
Okay. Katja, would you like to say something on the whole thing of commercialization and commodification of
Yes.
Yeah.
Yes, I
Please.
couldn't agree more actually with Kirsty on this. People do have the means, the opportunity, and the information. Traveling is cheap. Since you have the technology is giving you the options, the laws in different countries are giving you the options. So if you want to do it, you will do it. You will find a way, and you will find a way that suits your pocket, and you will find a way that suits your style, what you want from this arrangement. So basically, the only thing that we can do is to allow it, although it's not as popular as other forms of assisted reproductive technologies. But keep in mind that it is happening. So since it is happening, we need to make sure that it's happening in the ethical way, in the correct way, and the way that our society, the specific society that we live in, can tolerate. So basically, this is why we see so many different approaches on surrogacy from different countries. In France, it's completely illegal because they focus more on the exploitative nature, let's say, that surrogacy has on the use of human body. In other countries, it's other reasons. In Italy, it's basically religious reasons, Catholicism, that drives the regulation in the position of prohibition. In my opinion, since it's happening and since people will find a way and a destination to do so, it's better to do it at home, and it's better for it to be regulated and set in clear limits that are tolerated by that society. Children need to be protected, born in this way.
Katya, if you allow me, and this is a question that goes to Pantelis and Kostas too. Do you think that the whole problem of surrogacy tourism could be solved if we had common regulation at the level of the European Union, at least for the member states of the Union? And following subsequent question is whether why we don't have a unified, a common regulation, not only on surrogacy, but in general on assisted reproduction in the Union. So this has to do also with the problem of enforceability, you know. How can we make enforceable the laws, not only the contracts, but the laws on assisted reproduction and surrogacy in particular at the level of the Union? I know that I am excluding now the UK, but of course,
you made a choice.
We need to find ways to address the problem of surrogacy tourism, which is a real one, I think. Yes, Katja, please.
I don't want to hog the discussion. So I will just say this was one of this was a topic of a research that we've already done back in 2012, and the report was submitted in the European Parliament to see if there could be a unified, some unified rules on surrogacy all over the EU. And we looked at different countries from all over the world to see, to give examples and give options of how regulation could look like. Greece was one of the examples. The UK was one of the examples. Israel, no, not Israel, sorry. South Africa, we looked at many different countries, the US, commercial models, altruistic models, but we definitely came to the conclusion that unfortunately we are so different. Our societies are so different, and the values that we have are so different in each of those member states, that at this point, at least, it's impossible to get the same rules on surrogacy and assisted reproductive technologies. But I am hopeful for the future. I'm hopeful that we can agree on a set of rules, let's say, that will be acceptable to all. So about parentage following surrogacy, that should be something universal, especially within the EU. So it is not fair, in my opinion, that if a child is born through surrogacy in Greece, he has his legal parentage recognized from day one, from the moment of its birth. And if he's born in India and has French parents, then it's more difficult to get his legal parentage recognized in France. Definitely, we should agree on this, at least, that the children who are born in this way should be protected and their interests should be protected.
So, Pantelis, would you
Let's
like
see.
to? Yeah, thanks, Katia. Indeed, Pantelis, would you like to comment on
yes,
that?
of course. I believe that
question?
whatever ends up to further monitoring not in the strict way, but simply in the existing way, the merely existing way. Kostas paid me a compliment, but it's a rather saddening compliment, because these works like this research that I presented you should be done and could be done by the monitoring authority itself. It's very, very simple. The judges did not have to remember that, come on, I've seen those names before. They could have them because the whole procedure is a non-adversarial procedure. We declare as lawyers the names of our clients. It's very, very easy, but nobody wanted that. This is the only part that the lawmakers back in 2002 and 2005 failed, because they imagined the type of court that and the type of judge that Ronald Dworkin had in mind, the Hercules type of judge that would enter the case and resolve the case and balance things. However, there were truly, so whatever ends up to monitoring, correct monitoring, or whatever ends up to harmonization of laws is surely positive. One other aspect is that we have differences, cultural differences, I believe. For instance, I believe that though it was not intentional, it was known to the lawmakers in Greece that mostly foreign women, immigrants, independent workers that were working as economic dependent workers in Greece would offer, and they had no problem with that in principle. That's why they accepted that as a consequence, though they did not deliberately create the law for this thing to happen. So after 20 years, I think that we mostly got what we were expecting, apart from certain surprises. The one is that the monitoring authority did not work as planned, and the judges also did not play the role that the theoretics, the scholars had in mind. But to say something positive myself too, I believe in the next generations of lawyers, of intended mothers, and of gestational surrogates. This is a story that goes back to the past. Research and sociological researches go back to the past of the society's relations, because we see things that already happened. I have great confidence in generations that now enter the family programming, the reproductive age, and they were born within those regulations. They were born within these ideologies, and that's my hope for the future. So we simply have to be ready for that, and as everyone from our part act accordingly, because even as lawyers we do have a say as to whether the mother asks for a permission this way or the other way, or if the foul play that we sense should be allowed or not. So I believe in whatever we can do as from our stance. Without forgetting that the general spirit of that runs through the Greek legislation has always been tolerance with an eloquent element of trust towards the candor of the intentions of the parties. That's what I wanted to say.
Yes, great, Pantelis. Now, Kostas, if you like to comment on all this, and but also, just I know that I always add questions, but it is on my mind regarding that common European, approach do you believe that the Strasbourg court's judgments, very famous judgments regarding surrogacy and the legal system in France are really cornerstones in this prospect of regulation, of common regulation in relation to our topic?
Okay, going back to your first question about unification. First of all, there is a problem, okay, that IVF and medical assisted reproduction and surrogacy raise also the problem of parentage, for which the European Union does not have competence. Okay. Besides that, there is a proposal regulation for the cross-border, for the private international law aspects of parentage, which it does not regulate the parentage per se, but it could have impact on the applicable law and the recognition of parentage following surrogacy. But unfortunately, it doesn't seem that, I don't believe that we will have the unanimity to pass this regulation. But this does not mean that we should be pessimistic. I think being inspired by one of your articles, I think it was in 2008, the Journal of Bioethics, where you spoke, Taki, about unification. I think we should focus on uniformization of the more technical aspects. It's not necessary to agree that we all allow all the techniques of medical assisted reproduction, but we could agree that the consent should always be written. We could agree that the consent in medical assisted reproduction can be revoked up to the fertilization of an egg with a sperm. We could agree to create a European Union authority that will supervise, that will collect data, and that will share data with other member states. This does not mean, it's not necessary to share all the practices, to accept all the techniques, but there are technical aspects that can be regulated on the basis of health issues in the European Union, and this can already be very useful and share best practices and information. As regards Strasbourg, there has been, of course, the Court of Human Rights in Strasbourg has pushed forward the things, but I believe that sometimes the role that is attributed to the European Court of Human Rights is much more significant than it really is. I believe that the Court of Human Rights, it just pushed the courts of states, members of the Council of Europe, to be consistent in their approaches. Because finally, it is the national courts that have allowed the recognition of parentage following surrogacy. Okay. And all the courts of all the prohibitive countries, some have somehow guaranteed the recognition of this parentage. So, okay, the Court of Strasbourg pushes forward the recognition, but at the end of the day, it's the Italian court, it's the German court, it's the Austrian court, it's the French court. The French court, the French courts, after having asked for a legal opinion from the European Court of Human Rights that said you are not forced to recognize automatically the legal parenthood of the intended mother, they decided to proceed themselves and recognize automatically. Of course, later in 2021, there was a reform of the French legislature trying to force the intended mother to adopt. But anyway, but I will add a question to your question, whether that is constantly put forward in this debate, whether international convention would be the answer to the problems. And because there is this ongoing discussion and project in the Hague Conference. And I believe that as we see, at that point, there is no prospect of managing to have an international convention that would regulate international surrogacy, because the stakeholders have complete different interests. The countries that are liberal and allow surrogacy are in a position that have the best possible situation. It is in their best interest that European countries prohibit surrogacy. It's fantastic. And at the same time, they guarantee the continuation of this parentage created abroad. Even in the case in Italy, of course, we don't know what will happen if this piece of legislation of Meloni's government passes. But I don't believe that this will withstand the scrutiny of the Court of Human Rights. And let's not forget that in Italy, there are already hundreds of children born through surrogacy. So that's all from me.
Yes, thank you, Kostas. So, I think that there are also some countries in the middle. For example, the Dutch legislation. They tolerate, in a way, surrogacy. And please correct me if I'm wrong. They tolerate surrogacy. They follow a kind of a system of adoption with enforceable agreements and contracts. So my question to all of you is whether this kind of approach, which is a moderate approach, is more wise in the end. Instead of, regulating everything with very detailed, laws and I'm not sure. This is just an idea, and to go back to our gynecologist's question on whether we want that method, we really want that method or not as a principle, and why we need that method, why we need surrogacy, why those who are against are wrong. So, Katia, would you like to start now? If you want to comment on it.
Yes. In my opinion, this would be good for those parties that are very clear about having a good relationship and wanting the surrogacy arrangement to work. So if you leave it up to them, there is one argument that will say it's good, they will do it the way that they want, and it can be empowering, and it can be very freeing, and you may eliminate exploitative practices, but this also opens the way to exploitation, in my mind. So the line will be very, very thin, and it will be very easy to cross it if there are no clear rules that say this is allowed, this is not allowed, as we have it now in Greece or the UK. In the UK, yes, it is mostly unregulated at the early stages of the surrogacy arrangement up until the child is born. We've seen that this has not worked very well. I have heard from my interviewees that said for some of them, this is the best system because they can do whatever they like in their own way. And they are afraid that over-regulation might have a negative impact in the end. But I think there is a balance to strike, as with everything. If you struck the balance, if you find that golden ticket, let's say, then this will be the best solution. And that's going to be different from one society to another, at this point at least, that we cannot really agree on a set of rules.
Okay, Kirsty?
I agree totally. I think what you have written in the law in front of you sends a message about how things should be, and whether people adhere to that all the time is a different question. But it is about what ought to be. Also, I think Kostas was there as well at a conference in Denmark a week before last. I was really interested to see the detail of New York's they've regulated surrogacy recently. They've allowed it when it previously wasn't allowed, but it is so tightly regulated and in a commercial model. And so I'm looking forward to, that's my next project, is to sit and read that in detail, because it looks like it's, you know, even more detailed and coherent and whatever than what is proposed in the UK or what you've got in Greece. And yet it's a commercial model. But again, it's that whole, you know, this is how we want it to be done, even though you're New Yorkers and you're Americans and you're, you know, this is free society at its highest, isn't it? And so it's a very delineated process, and sort of quite interested to see how that's going to work. But again, that's a totally different model. It's just a very highly, if you compare it to California, it's just such a highly regulated US model. It's an odd one, but I think it's about having something written down which sends a message. And that's, so that and everything Katya said.
Yeah, great, thank you. So Padeli, if you like to say something on
Yes, I would like just to show you,
this.
this is the reason why regulation is always a good thing whenever a possibility exists. To say it, to cut a long story short, apart from things that should always be left outside the focus of the law, like love, like human relations that do not need to be regulated, all other things, from the time that they become possibilities, the best way to deal with them is to regulate them, to shed light on them, and, instead of allowing them to stay in the dark. If there was no legal, had there been no legal regulation of gestational motherhood, all those families would have not been created. It was merely impossible to do that under the Greek civil law or any continental civil law system. What would these people have done? I don't know, but this would not be the way to prohibit it. Despite all objections that one might have. And also I repeat what I tried to articulate earlier, we are now more educated, we have now more, and both emotionally and legally to deal with the foul plays. I'm not sure that everybody wants to deal with the foul play, but this is what I'm living with. This is the thing that I'm going to take with me tonight and every night and fight from my stance against it. But especially when we have the precious chance to speak out and talk to the younger generations, to our students, or to people that are now entering their reproductive years. That's what I would like to say. And sorry for showing that again, but I sense that it did not appear in your screens earlier. That's what I wanted to point out. By filtering, you can choose and you can create your own result. That's what I wanted to say. Thank you so much.
Yes, Federico, I would like to second Costa's comment on your valuable research. I mean, so rich findings, and it's wonderful. And I'm very glad to have you today to present that research.
Only a part of the whole story, because it is a part of the story. It's always the story that is told to court is not the story that really happened in life. But if we combine those things, we might be able to see what the outcome of our intentions or of our mistakes has been. That's the story that's the sociological of law approach. And always it always comes after the life events. That's another thing. So we are at the point now when we can take experience from what we have lived until now, if we want to affect the future of things, or have our say in what is to come, because this is the past of things. It has already been there. We cannot do anything to change it, but I believe that it is better that it occurred that way, and I'm not prepared to accept that all those life stories that are now presented in small dots were all foul play, or they were all stories of exploitation or bad balancing of, and that also is something that I have to report from reading the cases. It was most often the case that despite all problems, you could realize the need and the good intention, especially from the part of the intended parents. You could see that. It was not always a checklist, 1, 2, 3, okay, take the permission, go and create your families. So, of course, I would not be in favor of abolishing the whole institution. I mean, no, not at this point.
Okay, so Kostas, I would like to go back to the question of principle. Do you think that why those who stand against surrogacy are wrong?
Listen, I believe that this can be answered with another question where, at least in my opinion, the answer is clear. Did they reduce, by prohibiting surrogacy in their countries, the overall unethical agreements, the overall exploitation of women involved in these reproductive activities? My opinion is that they clearly did not. For instance, and I will take just one example. India, which has been a hub for surrogacy for couples from all over the world, at some point decided to close it completely to foreign intended parents. And sometimes they decided to prohibit commercial surrogacy. Did this lead to more protection of women worldwide? Not from the perspective of our national legal order, but generally, because in my perspective, in the whole ethical conversation, we should not limit our principles to the geographical limits of our country or of our legal order. So from what I have read, from what we have discussed, and also to the global surrogacy forum that Kirsty has just mentioned, it seems that this prohibition led to more lack of transparency. It has delocalized to legal orders where there is less significant protection. There are more people that are involved in procedures that are not controlled, that are not verified. And the countries that prohibit finally, and those that stand behind their prohibition, they, with their decision, with their framework, they do not contribute in any possible way to the protection of the people that have been potentially been exploited, which we cannot exclude it. I believe that there are those people, even in Europe. And I believe that there have been cases, for instance, in India, which thought that it is a country which could have promoted exploitative practices. I believe that there might be clinics in India that are more respectful than clinics in Greece or in other countries. So my argument that their prohibition is twofold. The first thing is that they did not reduce the overall exploitative nature of the overall result of exploitative practices. This is the first. And secondly, by systematically recognizing the intended parents and their parentage, this means that indirectly, it seems that they are not convinced by some of their most harsh arguments against surrogacy.
Thank you, Costa. I think Kirsty needs to leave us now. She sent some message. So I'd like to thank you once again, Kirsty, for your valuable insight If you like to add something, please.
No, thank you. It's been really interesting seeing that and that research presented. I'm going to go and explore that website and have a good look at it as well. But it's been, a really interesting afternoon. Thank you.
Thank you very much again. On behalf of Biomedlex, also, Christy, for your contribution.
Thank you.
To our
Sorry.
discussion. So bye-bye.
Thank you,
Bye.
Kirsty. Bye-bye.
Bye,
Bye-bye.
Katja.
Okay, I'm not sure if we need to continue in English now for a few moments. I don't know if we have any English
We don't seem to have
foreign attendee.
We don't
Sorry?
seem to have foreign attendees right now. If anybody is a foreign attendee, I kindly ask them to raise their hands, but I don't think there are any. We are 21 participants in the meeting at the moment.
Yes.
So we might be able to end this conversation in Greek.
To
or-
continue
That's
to continue in Greek for a few minutes. Okay. Εντάξει, λοιπόν, έχουμε μόνο μία παρέμβαση που βλέπω εδώ από την Ματίνα Τελειώσει. Ματίνα, θέλεις να ανοίξεις το μικρόφωνο σου να μας το πεις? Για λίγα λεπτά ακόμη θα το κρατήσουμε. Αν κάποιος έχει μια ερώτηση, παρακαλώ.
Απλά, αν θέλετε να την κάνετε αγγλικά, για να μπορέσουμε να τη βάλουμε στο βίντεο της εκδήλωσης, το οποίο είναι αγγλικό, και να κάνεις μετά μια αποφώνηση στα αγγλικά. Θα ήταν μια ιδέα. Αλλιώς θα την κάνουμε με υποτίτλους. Οπότε, όπως προτιμάτε, όπως θέλετε. Ας το κάνουμε.
Okay, we can continue in English. This is the simple. We can continue in English. There's no need to change that. Can we?
Yes, of
Yes.
course. Δεν εξαρτάται από μένα. Μισό λεπτό.
Just for the others, please upload questions or any other comments, because we don't have enough time. If you want to comment on something or say something, please, you can do it now. Okay, so
I would just like to thank you for the opportunity for today's discussion, because surrogacy is such a small issue, let's say, and we don't really find that many people interested in this very small part of law, of health law. And it's really good to see that there is a community out there that is still interested and still researching. It's very important, in my opinion, to keep feeding the world, even just the academic world, with our data, and exploring how surrogacy works in practice. So thank you, everyone, for those insightful presentations to the speakers, and also for the comments already made.
Good. Thank you very much, Katja, for your contribution too. And Martina, can we see now what Martina said in the chat? She says that I wonder whether a more modest model in the form of minimum core obligations could work at regional level. So what do you think? Is anyone who wants to comment on that question, on that idea?
Maybe
Adeli or
Kostas?
Costa? Or Katja?
I would say that if there is a chance of something being successful, is the minimum obligations, because the more ambitious one seems, it seems that we are very far from that, because the opinions formulated in different countries are most of the times formulated in very absolute terms. If you discuss with people, for instance, in France or in Italy or other where in other destinations that are against surrogacy, they are really very ferocious in their point of view. Of course, I will try to, I'm trying to figure out what could be the problems. One problem also in the minimum core obligations is that if there is a practice established over the years, even about IVF consent or other issues, there could be some reactions from practitioners. But at least that the minimum core obligations is something more feasible as a goal to set. And even if this could not work, we could at least create some monitoring mechanism and some mechanism that will allow us to share information about best practices. Okay.
Yes, and Martina says that independently of cultural differences and objections, we can reach a common ground regarding the so-called minimum core obligations. The problem is that surrogacy as such is an exception in European legal systems. So we have only, at that moment, we have only Greece with a clear legitimate surrogacy system. The UK has left the Union, so it's only Greece. There are no other countries in the European Union that have adopted the method.
Cyprus.
Cyprus has.
Cyprus. Sorry, I didn't know. Okay, two
Cyprus
countries,
perhaps Portugal,
out of
tried
28, 27. So it's an exception. So if we are going to reach to consider a kind of common ground, surrogacy is excluded by definition, by default, I would say, because it's an exceptional method. That's the problem, Martina, I think. So, Padeli, would you like to...
There could be core obligations discussed and drafted as far as the consequences of the method are considered throughout the Union. Because I believe that even if the method per se would not be introduced into other countries for several cultural reasons, the anticipation of the method should not be so different from country to country, especially as far as rules are concerned. And at that point, I believe that we must insist and we must meet more often and discuss things, because we have to persuade the other interested parties, especially the community of doctors, the medical community, that rules and other sensitivities that have more ethical grounding would not necessarily harm their scientific goals, because I sense that there is a huge difference on that. We have a huge disagreement on that field. I believe especially that the medical community focuses on having a successful method, a successful pregnancy, and they are not ready to import in their thoughts certain sensitivities, or even the reproductive tourism model. Those that are in favor of it sort of sense that might sense that having more rules would make that impossible. No, this would make that possible, and with rules regulated, and not with a laissez-faire notion. So this is a discussion that we have into which we have to enter, I believe. And I believe that, again, as a generation, we are at a checkpoint. We were grown and taught by our professors to have this eloquent element of trust for whatever all possibilities should be turned into rules and laws, and everything would go fine. And we're now at the point where we see the dead ends that this led us, or the problems that we faced. But we should not, the conservatives that even from back then said that, come on, this is no way to go. Things are going to become very, very complicated. now they seem to score a point against those old thoughts, but I don't believe that this theoretical debate has ended. I don't believe that we are at the point that we should hand over our weapons and say, okay, you were right, we cannot go further with that, we should stop that. That's my sense. But again, we have to listen to women, to the feminist criticism and things. We have to carefully listen to the medical community, the medical science, what they have to say, as also their science evolves and makes possible things that were impossible until yesterday. So, okay. But I so much want to be allowed to be part of this discussion. I mean, as a stance, not as a person. You understand? As a lawyer, as a legal professional.
If
Okay.
I can add something, yes, I
Sure,
completely
Katia.
agree. I think let's not forget that all these have been made possible very, very recently. IVF has been made possible in the late 70s. And surrogacy, the first surrogacy cases that we've seen on the media were in the beginning, the start of the 1980s. So basically, we still have a long way to figure out how this works and how this should work in terms of regulation. I think we should not forget that it's very, very recent. So we may think now that 20 years, for example, for the Greek legislation is a long time, but it's not. If you consider that 30, 40 years ago, all these options were not even available to people. And I think that we are now making a lot of progress, and the work of researchers, of legal medical practitioners, of people's experiences is very, very important. So the more that we make people aware of how this works in practice and how this should work in a better way, then the closer we are to a solution that will work for everyone, and the closer we are to a convergence of ideas and finding a common ground that we can all agree on. I think that we still have way, but it's still very early days. So we should just be hopeful and continue our work.
Yes, I think this was the best ending of our meeting, if you agree. Of course, we need the input from the medical professionals. I agree with that inside the chat. So I would like to thank you all very much for joining, for contributing, and for the wonderful presentations by our speakers. And of course, please stay in touch with our social media. Biomedlex soon will announce, soon I believe, will announce the next event after the summer's vacation. So thank you very much again for your attention, and have a nice evening. Bye-bye.